A Marital Law Guide. Chapter 1. The Legal Aspects of Marriage. The legal aspects of marriage. Marriage is not as simple as falling in love, doing the ceremony thing and signing a piece of paper. There are laws about marriage differing in every state and country in the world. Even though they're generally basically the same, there are differences. To get information about marital laws in your county, look in your phone book under county or city government, then look under licenses for marriage license or find your county website on the internet. Many of these offices have a short guidebook or fact sheet about the marriage procedure. Some are now requiring a premarital course before marriage and even a divorce-proof contract where they won't divorce you unless you've been married for at least 2 years, but this is currently rare. Nevertheless, some county justice systems are swamped with divorces. Call your local marriage license office at the county administration building and ask about local laws. Most states require official documentation when you go to get your marriage license from the civil office, like a photo ID and a birth certificate, divorce and annulment papers if applicable, and the death certificate of a deceased spouse. There might be a medical or blood test requirement because you need to disclose if you have a sexually transmitted disease, more specifically, AIDS, to your new spouse. A few states even require both parties to get complete physical examinations performed by a doctor. There are age of consent laws about a minor, somebody under 18, getting married. In some states, it's illegal; in others, the minor needs a parent's signature. In Massachusetts, the age is 12, in Hawaii, 14, in Arkansas, 16. There are laws against relatives marrying, such as first cousins marrying, laws against polygamy, 2 or more wives, and laws against marrying another while you're still legally married even though you may be separated. You have to cut the knot legally first before you marry again. If you don't, there could be all kinds of hassles when you die as to who has the rights to your estate. A marriage entered into to fool the U.S. Immigration and Naturalization Service is illegal and subject to criminal prosecution and deportation. ins.usdoj.gov, ins.gov. Currently, 26 states have a waiting period of between 1 to 5 days before you can have the marriage ceremony. A recognized public official must sign the marriage license, typically a member of the clergy or court clerk, notary, judge, justice of peace or ship's captains, and some military officers. Some states require a witness or 2, some don't. The wife typically takes the husband's surname, but this is becoming less common as women choose to keep some of their independence. When you change your name, you must inform all government entities, banks, insurance companies, etc. When it comes to money, each side is obligated to support the other when and as required. The couple can now file joint income tax returns. They are entitled to spousal benefits on retirement, pension, medical plans, and insurance rates are generally cheaper for couples. There are such things as proxy marriages, where if a person can't attend his own wedding because he's in jail, in the military, or otherwise occupied, someone else can stand in his place. Homosexual marriages are currently illegal in some places. Some benefits of marriage are: one spouse is automatically entitled to a portion of the other spouse's estate at death even if they're not in the will. Lower insurance costs as a family. Privileged communication, one spouse can't testify against another in court. Right to benefits dependent on spouse's contribution to Social Security and other pensions. You can make medical decisions about an incapacitated spouse. You can visit your spouse in the hospital during times of crisis when only family are allowed to visit them. There are many other minor local laws. Some states have laws stating that depriving the spouse of sex is grounds for divorce. Married couples don't legally have to live with each other. Some states state that it's a wife's responsibility to bear children if the husband wants them, while other states state that it's clearly the woman's decision to do what she wants with her body. Consider going to your local courthouse to read up on marriage laws. For general information about current marriage and divorce laws like age, waiting period, etc., refer to the World Almanac, which should be at hashtag 031 at the library, or go to the Family Law section at hashtag 346.7101 and K559 or KF529 at the library. law.cornell.edu/topics/marriage.html. NACO.org, National Association of Counties. For information on the web about any county government department, use the following formula. Try co.name of county. 2 letter state abbrevation like co.losangeles.ca.us. For cities, try ci.name of city. 2 letter state abbrevation like ci.pittsburgh.pa.us. For communities like towns and villages, try community.name of community. 2 letter state abbrevation like community.floyd.va.us. Capacity to consent. A marriage requires 2 consenting people. Not consensual shouldn't be all that hard to define. It means the person is either in a position where they're not of sound mind, cannot or does not understand what it means to be married because of mental illness, drugs, alcohol, sickness, etc., or they're put into a position where they have no choice, namely coercion, threats, etc. If a girl's father goes up to the guy who impregnated her and tells him to marry the daughter otherwise he'll shoot him, this is called a shotgun wedding. It's illegal and enough grounds for annulment. If fraud is involved, like getting married in order to attain immigration status, that could be constituted an illegal wedding and annulled. Arranged marriages could be enough grounds for coercion in the United States. Back in the old country, in some cultures, if the old man tells his daughter to marry her smelly 60-year-old uncle, she has no choice, but in America, it's coercion. If you get married like this, you have the right to get it annulled. Engagement failure. When 2 people get engaged, it doesn't mean much legally because they're not married, but if they break up, there's a general legal protocol, namely that the one who breaks up is the one who loses the ring. All other gifts not relevant to the direct engagement ritual are gone. If you give your girl your car just because you love her and she breaks up with you, you might try to get it back in court, but you will have a hard time because it was a gift. If you give her the car contingent upon getting married and she breaks up, she technically violated the contract, so you might be able to get it back in that case if you can get evidence like witnesses who will say that the gift was contingent on the marriage. It could even be construed as fraud on her part. Gifts of courtship before the engagement are generally not recoverable. If the engagement doesn't work out, some states have laws or common law case decisions which require the girl to give the ring back, but protocol says the one who cheated or backed out is the loser. If the girl backs out, she returns the ring. If the guy backs out, she keeps the ring. If it's a family heirloom, give it back. The legal reasoning is that the marriage contract was not fulfilled, so it doesn't satisfy the criteria of gift. If you're the guy and didn't cheat and want the ring back and she doesn't want to give it, you have to take her to small claims court or civil court if it's worth more than $5,000. Although corny, try to give the ring and other gifts in front of witnesses and state specifically that they're gifts contingent upon fulfillment of the marriage contract. There are gifts called gifts of pursuit which are given when you're chasing the girl and not as part of the engagement, so they're harder to recover because they were given before the engagement. Birthday and other special occasion gifts are considered different than engagement gifts, so they're harder to recover too. If the girl tried to suck you out of gifts then leave you, you might be able to sue her for fraud. Gifts to a minor you plan to marry can't be recovered at all. Gifts from third parties must be returned, especially if you're the one who caused the breakup. For example, if his mother gave you a sewing machine for the new house and you break up, give it back to be a decent person and to avoid hassles. Although rare, some states hear cases of alienation of affection where you can sue a third party, the girl your man was cheating with, for breaking you two up and causing emotional distress. Leaving property to lover, gay or straight. Quite often, if one of an unmarried couple dies, as next of kin, the parents or kids come in to claim the stuff. Your only recourse is to make up a will beforehand and specify that this person was your faithful lover and that you're leaving everything to him or her. Cousins marrying/consanguineous unions. First cousin marriages are illegal in some states. Second cousin marriages don't seem to be, but I don't even know what a second cousin is. I think it's the cousin of your cousin. A consanguineous union is the offspring of first cousins. Asians used to marry their first cousins, but it's dying down. There are even laws against it in some countries. People used to marry their cousins in the past simply because there were very few people that people socialized with. Imagine living on a farm in the 18th century. The furthest you could go in one day was about 10 miles by horse, then 10 miles back, so dates were rare. The roads were really bad back then, so you got 10 miles if you were lucky. That means that in your lifetime you wouldn't meet anyone who lived more than 10 miles away from you. There was a case about a man who had a son by his first marriage, then remarried and had a daughter, so they were half brother and sister. It was illegal for them to marry because they had the same biological father with different mothers. However, as far as I know, if a guy and a girl become stepbrother and stepsister by marriage with no biological link, they can marry. Relatives marrying/cousins marriage laws. If a man marries his sister or half-sister, they shall be publicly disgraced and driven out of the community. He has had intercourse with his sister and must suffer the consequences. Leviticus 20:17. Most harmful genes are recessive by nature, that is to say that they are dominated by an equivalent safe gene. Generally speaking, we need to inherit 2 copies of the recessive gene, one from each parent, for the disease to have any effect. Producing offspring from a close relative increases the risk of the child receiving 2 copies of the same recessive. Even though we commonly think of incest as the father manipulating or straight out forcing his young daughters to have sex with him, in the legal sense, incest refers to anyone marrying or having sex with someone who is so closely related to them that they're not allowed to legally get married, like a brother and a sister. In most states, any relations closer than cousins aren't allowed to marry. In some states, first cousins are allowed to marry, in others only second cousins or more distant relatives can legally marry one another. In most states, the closest relative you can marry is a second cousin. Some states allow first cousin marriages with a genetic counseling certificate. In general, a marriage may not take place in the United States between the following relationships regardless of whether the players are legally tied or illegitimately birthed: an ancestor and descendant parent, grandparent, great-grandparent, child, grandchild, great-grandchild, brother and sister, full or half-blood, uncle and niece, aunt and nephew. If this is an issue, check with the Marriage License Bureau in the town where the marriage will take place. Even though in the past, blood relatives often had sex with one another in some cultures, currently, incest is a universal taboo worldwide. The most standard definition is probably anyone having sexual relations with a parent, son or daughter, brother, sister, half-brother or half-sister, with one parent in common, uncle, aunt, niece, nephew, grandparent, great-grandparent, grandchild and great-grandchild. Some places legally prohibit relations with a first cousin, stepchild, step-parent, parent-in-law, child-in-law, brother-in-law, sister-in-law, a spouse's grandchild from a previous marriage or grandparent. Some places are pretty lax with the law relating to in-laws and stepchildren or parents. If there's no blood tie there, the law prefers to ignore it, but this is not so in all places. I've seen a few stories in the media where a stepbrother and sister were criminally charged for having a baby together and getting married. In the end, they weren't allowed to be legally married, so the marriage was annulled, but they continued to live together without the marriage license. As far as I know, marriage between first cousins is legal in about 20 states. If you plan to marry a cousin, second cousin, niece, nephew, uncle, aunt, etc., you should check with local laws before you proceed. The anti-argument asserts that there is a 1/16 to 1/32 chance that common genes from the grandparents' gene pool could cause complications in the subsequent births of 2 relatives conceiving. However, counter-arguments say this is all crap. Birth defects are an individual thing with everybody. If a grandparent has a dominant gene for something like MS, there's a slight risk that the MS gene is passed on from both partners to the baby, but it's not that high. Step-siblings should be allowed to get married as long as there's no bloodline, kinda like one comes from one parent biologically and the other comes from separate parents altogether. For example, a woman comes into a marriage with her daughter. A guy marries her and his son lives with them, so you got technically step-siblings living in the same house, but there's no bloodline, so if they want to get married, no problem. If there's some blood relations, like the father brings his 2-year-old son into a new marriage, has a biological daughter with his new wife, and 20 years later, these step-siblings fall in love, I heard that they're legally not allowed to get married, but I saw at least one couple fighting this in court. If anyone knows the laws in this area, I ask that you please send it to me so I can add it to the next edition of this book. It is legal in all 50 states to marry your second cousin. In Indiana, Kentucky, Nevada, Ohio, Washington, and Wisconsin, you can't marry your first cousin or first cousin once removed. Your first cousin once removed is the child of your first cousin. In Arkansas, Delaware, Iowa, Idaho, Kansas, Louisiana, New Hampshire, Michigan, Minnesota, Missouri, Mississippi, Montana, North Dakota, Nebraska, Oregon, Oklahoma, Pennsylvania, South Dakota, Texas, West Virginia, and Wyoming, you cannot marry a first cousin, but you can marry a first cousin once removed, the child of a first cousin. In Louisiana, Mississippi, Oregon, West Virginia, you can marry an adopted first cousin. If you marry your cousin where it's legal, then come back to the state, they'll let you get away with it in Indiana, Kansas, Louisiana, Nebraska, Oklahoma, Washington, West Virginia, Wyoming. In Indiana, first cousins, or first once removed, can get together as long as they're both over 65 and infertile. In Wisconsin, the woman has to be over 55 or at least one of the two people to be infertile for first cousins to marry. In Alaska, Alabama, California, Colorado, Connecticut, Florida, Georgia, Hawaii, Maryland, Massachusetts, New Jersey, New Mexico, New York, Rhode Island, South Carolina, Tennessee, Vermont, Virginia, and Washington, D.C., there are no cousin marriage laws. Marry a relative websites. chenouthsite.com/chenkiss.htm, kissing cousins, listing of cousin marriages. Consang.net, International Consortium on Consanguinity, worldwide statistics on marriages between first cousins, uncles, and nieces and other consanguineal relationships. CousinCouples.com, Cousin Couples, interactive support network for those romantically involved with their cousin. press.uillinois.edu/f96/ottenhay.html, Forbidden Relatives, the American myth of cousin marriage, challenges the belief widely held in the United States that legislation against marriage between first cousins is based on a biological risk to offspring. wordofTruthradio.com/question/37.html, Can we marry our cousins? A biblical perspective on cousin marriage. CousinCouples.com. en.wikipedia.org/wiki/cousin_marriage_case_in_the_United_States. AskDrWarren.com. biharunjuman.org/marrying_relatives.htm. CousinCouples.com. lawlibrary.ucdavis.edu/lawlib/jan97/0136.html, Cousins marrying. straightdope.com/column/041001.html, What's wrong with cousins marrying? Chapter 2. Marriage Law Info. Marriage law websites. Every county in the United States has certain laws about marriage. You can find this information by calling your local county clerk's or county records office. Get blood tests necessary to get the marriage license. Most states require blood tests for venereal diseases, and at least 14 states require that couples receive information about AIDS. Contact your local Health and Human Services office, AIDS helpline, or your doctor for information about marital test requirements. usmarriagelaws.com. uslegalforms.com. liveabout.com/relationships-4145432. weddingvendors.com/marriage-license-laws. weddingvendors.com/marriage-license-laws/United-States. imapp.org, Institute for Marriage and Public Policy. marriagedebate.com. 911-legalhelp.com. 1800bride2b.com/article/marriage laws_chart.html. family.findlaw.com/marriage/marriage-basics. family-law.freeadvice.com. family-law.freeadvice.com/commonlawmarriage.htm. getmarriedanywhere.com. law.cornell.edu/topics/marriage.html. law.cornell.edu/topics/table_marriage.htm, state marriage laws. lectlaw.com/tfam.html. legalaffairs.org. lmaw.org, Legal Marriage Alliance of Washington. loveandthelaw.com. marriagesite.info. nalo.com/law center. usmarriagelaws.com. Marriage license websites. lawfullywedded.com. marriagelicenses.com. modernbride.com/budget/question/license mbm0900.html, marriage license regulations. Marriage license by state. ncsl.org, state legislatures. Call these numbers to help you navigate your way through the state government systems of your choice. Think of them as your state government operators. Alabama. 334-242-8000. state.al.us. Alaska. 907-465-2111. state.ak.us. Arizona. 602-542-4900. az.gov. state.az.us. Arkansas. 501-682-3000. state.ar.us. ark.org. California. 916-322-9900 North. 213-620-3030 South. ca.gov. state.ca.us. agency.resource.ca.gov/official. dhs.ca.gov/hisp/ch/over/marriage/faq.htm, California marriage. dhs.ca.gov/hisp/ch/over/marriage/generalinfo.html, California marriage license, registration and ceremony information. Colorado. 303-866-5000. state.co.us. Connecticut. 203-566-2211. state.ct.us. Delaware. 302-739-4000 Kent. 302-577-2011 Newcastle. 302-856-5011 Sussex. state.de.us. Delaware.gov. District of Columbia. Washington, D.C.gov. Florida. 904-488-1234. state.fl.us. foren.edu. Georgia. 404-656-2000. state.ga.us. gainty.org. doas.state.ga.us. Hawaii. 800-468-4644. state.hi.us. hawaii.gov/health. Idaho. 208-334-2411. state.id.us. accessidaho.org. Illinois. 217-782-2000. state.il.us. cyberdriveillinois.com. Indiana. 232-1000. State.in.us. in.gov. ai.org. Iowa. 515-281-5011. State.ia.us. Kansas. 913-296-0111. State.ks.us. accesskansas.org. Kentucky. 502-564-3130. State.ky.us. kydirect.net. Louisiana. 504-342-6600. State.la.us. Maine. 207-582-9500. State.me.us. Maryland. State.md.us. Sailor.lib.md.us. mdarchives.state.md.us. Massachusetts. 617-727-7030. State.ma.us. mass.gov/portal. mass-doc.com/Massachusetts_marriage_certificates, Massachusetts. Michigan. 517-373-1837. State.mi.us. Michigan.gov. mlink.lib.umich.edu/me-government/me-government-index.html. Minnesota. 612-296-6013. State.mn.us. revisor.leg.state.mn.us. Mississippi. 601-359-1000. State.ms.us. ms.gov. Missouri. 314-751-2000. State.mo.us. services.more.net/stofmoinfo/services. dis.state.mn.us, Department of Education. Montana. 406-444-2511. State.mt.us. mt.gov/css. discoveringmontana.com. Nebraska. 402-471-2311. State.ne.us. Nevada. 702-687-5000. State.nv.us. co.clark.nv.us/clerk/marriage_information. HTM, Nevada. New Hampshire. 603-271-1110. State.nh.us. New Jersey. 609-292-2121. State.nj.us. newjersey.gov. New Mexico. 505-827-4011. State.nm.us. New York. 5518-474-2121. State.ny.us. chrisny.org/government/governmentnewyork.html. NISE.gov. health.state.ny.us/NISDO/consumer/VR/married. New York State Department of License. New York CMarriageBureau.com/about/FAQ.html. New York CMarriageBureau.com/download/marriage_officiant_registration. North Carolina. 919-733-1110. State.nc.us. ncgov.com. legislature.state.nc.us. sips.state.nc.us. North Dakota. 701-328-2000. State.nd.us. discovernd.com. vm1.nodac.edu. Ohio. 614-466-2000. State.oh.us. freenet.columbus.oh.us/government-center/state of Ohio. osc.edu/ohio/legislative information. Oklahoma. 405-521-2011. State.ok.us. Oklahoma osf.state.ok.us. youroklahoma.com. Oregon. State.or.us. Oregon.gov. Pennsylvania. 717-787-2121. State.pa.us. Rhode Island. 401-277-2000. State.ri.us. South Carolina. 803-734-1000. State.sc.us. mycgov.com. South Dakota. 605-773-3011. State.sd.us. Tennessee. 615-741-3011. State.tn.us. TennesseeAnytime.org. Texas. 512-463-4630. State.tx.us. Texas.gov. Capital.tlc.texas.gov. tdoc.texas.gov, Department of Commerce. Utah. 801-538-3000. State.ut.us. Utah.gov. Utah.edu/off-campus information/state of Utah. Utahmarriage.org. Vermont. 802-828-1110. State.vt.us. Virginia. 804-786-0000. State.va.gov. State.va.us/home/govermt.html. Virginia.edu/admin/govrel. Washington. 360-753-5000. State.wa.us. Access.wa.gov. leginfo.leg.wa.gov. West Virginia. 304-558-3456. State.wv.us. wvnvm.wvnet.edu. Wisconsin. 608-266-2211. State.wi.us. Wisconsin.gov/state/home. Wyoming. 307-777-5910. State.wy.us. State.wy.us/wgov/wl. Some specific worldwide marriage license office websites. acgov.org/auditor/clerk/marriage1.htm, Alameda County, California. bdm.nsw.gov.au, New South Wales, Australia. bmd-certificates.co.uk/marriage.html, England. cdpe.state.co.us/hs/marriage.html, Colorado. ci.boston.ma.us/registry/registermarriage.asp. cltr.co.douglas.nv.us/marriage-faq.htm, Douglas County, NV. co.calhoun.mi.us/docs/marriageform.html, Michigan. co.clark.nv.us/recorder/certs.htm, Clark County, NV. co.san-diego.ca.us/arcc/services/marriage_certificates. dhfs.state.wi.us/vital records/marriage.htm. Get a marriage record in Wisconsin. dhs.ca.gov/hisp/chs/over/public marriage order certificates, California. doh.state.fl.us/planning_eval/vital_statistics, Florida. doh.wa.gov/sphl/chs/cert.htm, Washington State. DominicanWeddings.net/certificate.htm, Dominican Republic. Dorado.ca.us/county clerk/confidential.html, El Dorado County, California. dph.state.ct.us/op/pdfs/vs-39m.pdf, Connecticut. gro.gov.uk/gro/content/marriages/obtaining marriage certificates/index.asp, England. Hawaii.gov/health/vital-records/vital-records, Hawaii. health.state.ga.us/program/vital-records/marriage, Georgia. health.state.ny.us/vital_records/marriage.htm, New York State. hhs.state.ne.us/sed/macert.htm, Nebraska. hss.state.ak.us/dph/bvs/heirloom_marriage/default, Alaska. italiamerica.org/id3.htm, Italy. italiandualcitizenship.com/id3.htm, Italy. kdhex.gov/vital/marriage.html, Kansas. lawvote.net/recorder/birth_death.htm, Los Angeles. manchesternh.gov/citygov/clk/records/marriage-certificates, Manchester, NH. oc.ca.gov/recorder/markerti.htm, Orange County. oph.dhh.state.la.us/record-statistics/vital-rec, Louisiana. saginawcounty.com/clerk/marriage.html, Michigan. ukcertificates.com, United Kingdom. vegasmarriagecertificates.com/order.php, Las Vegas. Chapter 3. Common Law Info. Living together/shacking up without a marriage license. If a man wants to leave a toothbrush at my house, he can damn well marry me. Michelle Triola, actor Lee Marvin's girlfriend who sued him for financial support after the breakup. Living together without being married was once considered a sin and cultural taboo, and it's still a sin for those who carry the torch of Christianity, but alas, times have changed. What was considered a chic oddity in the 1960s and 70s has permeated the culture so much that credit card companies now put the term co-applicant on their application forms as opposed to spouse. The traditional argument is that you don't buy a car before trying it out, just like you don't get married before checking out how you each live as individuals and together as your lifestyle in the same house or apartment, but it goes beyond this. People shack up for many different reasons. A guy might offer his poor girlfriend a place to live. Two people going steady but don't know if they love each other might move in together simply because it's cheaper that way. Some people, like me, don't really like the government and don't feel that two people in love need to get a contract from Big Brother authorizing their relationship. Follow your own intuition and wisdom, but disregard what parents and others think of the concept of you two living together in sin, fun, like and self-discovery. Their comments about your partner could be useful, but their comments about living together before marriage or out of wedlock don't hold water in a free society. Currently, about 6 million couples live out of wedlock in the United States. The bottom line is that shacking up is not really a trial run for a marriage. In my opinion, it should be an end in itself. You do it in the moment in order to be with each other, save money, etc., but you don't do it with the expectation that this is the first phase of the marriage ritual. You take it as it is. If it's great, you can get married if you want. If it's not, you either live together for a while for pragmatic convenience sake, but then one leaves and you move on, probably shacking up together with someone else to see how compatible you are day to day. In fact, serial monogamy is an emerging trend in modern society, staying with different partners for varying lengths of time as you live your life. Just like the military for me at the age of 17 was a good way to learn about how to live with people, I think shacking up is a good way to get beyond your natural, inherent self-centeredness to learn how to live with others. At the very least, living together will teach you some basic life lessons about other people, their fragile egos and weaknesses, their beauty, love, hate, etc. You either learn to be a compromiser and a team player or play tit for tat, purposely getting on each other's nerves. Where is the line between independence and being emotionally connected? Where is the middle ground between having fun and living out the mundane responsibilities? How far do you go in the sacrifice of your standards? You acknowledge that he isn't perfect, that everybody is human, but how low do you go before you leave or kick him out? If he's too immature to take care of his own life, how could you ever have entertained the possibility of marriage with him? You can never get enough of learning about living with people in the same house. If you go in with the attitude that you're just learning about life, you'll make out a lot better than going in expecting this situation to lead to marriage. The moralists seem to think there's a great moral divide between people that live together out of wedlock versus people who get the civil marriage license and take the religious vows, but in the cold, hard reality of day-to-day life, the reasons are often much more mundane and practical. It's convenient and cheap for a boyfriend and girlfriend to live together in many cases rather than not. Life is hard. Providing a roof over one's head while trying to get an education and make one's way in the world is not a cup of tea for us people born without silver spoons in our mouths. For a young guy and young girl, this is often the only practical way to make a go of it. The statistics suggest that people who live together then marry have much higher divorce rates than people who don't live together but get married and then live together, presumably because these people are not as conventional nor as serious about their wedding vows when they do eventually take them. This runs counter to the main argument for cohabitation, which is namely that you should test the waters by living together before you do it. Another argument is that people who shack up do so for many different reasons, some of them less than for pure love, while people who marry right off the top feel that they love each other and want to be together forever. Even though many cohabitating couples marry because they have a kid or just do it by osmosis, they don't have this strong love that the immediate marrying lovebirds do. The fact is that people with uncommitted attitudes towards each other often live together. I say, so what? It's not much different from roommates except that there's sex involved. Take it any way you want, either as a casual living arrangement for now or as a preparatory course for marriage, but either way, be wary of getting trapped, something like getting financially dependent on the guy without your own meal ticket independently, or having a baby. Then you're stuck with him at least for a while even if you don't love him. Trust your instincts. Don't take living together too hard. If you love each other, you tie the knot. If you don't, you move out. So what? Just like with same-gender roommates, there are good times and bad times. It's part of growing up. It's no big deal. Some guys want their girls to move in with them so they can control them. Some girls want to move in with their guys because they're afraid he'll either break up if they don't, or that this is the way to snag him into marriage. Like I said earlier, the purest motive is to move in together to live life in those moments as they happen. Whatever happens happens with no expectations going in. Some types of living together arrangements that generally don't work out for very long are: big age difference, young girl fresh out of mama's house, different religions, different cultural background, i.e., the hip-hop girl and the jazzy guy, disapproval of your lover by friends and family. One is either married, living apart, or in the process of divorce. One has children, either with or without custody. Don't talk much. Don't relate much beyond sex. Don't really know each other. How to determine marriage material if you're living together are to look for the following points. Do you talk regularly? Do you do romantic things together? Are you intimate physically as opposed to just sexual? When you have spats, do you get over them? Do you like being with each other? Do you feel safe, trustworthy, and loyal to each other? Do you like the same things? Do you live the same lifestyle? Are you respectful and kind to each other? Do you want the relationship to work? Are you relaxed, unstressed people, or is one or both of you tense? Do you share values with respect to kids, money, career, lifestyle and marriage? If you really like each other but think you're too young, too poor, or not established enough career-wise, I personally think that shacking up is better than getting married right away. It's a timing thing. You have to feel ready for it. You could propose, give her an engagement ring, move in together with an understanding that you'll get married when he finishes his schooling and becomes an MD 3 years from now. This prospect of getting engaged then moving in together works for a lot of people to appease their conservative relatives. Living together is good to help you get beyond the fog of romance to learn the day-to-day realities of living together like. What are your thoughts on money? Do we keep assets together or apart or do both, have an account which each contributes equally to for bills and separate ones? Both names on the lease or just one? If you watch court TV, ex-lovers always argue about major purchases like a car, stereo, etc. Either one buys it and keeps the paperwork as sole owner, or if you both buy, get the paperwork stating that you're equal co-owners. Don't give the other your credit card unless you're prepared to absorb their frivolous purchases. How do you pay for the rent or mortgage? How do you pay for food, bills, etc.? Does one pay and the other not, or do you go 50-50? Split of chores. Cleaning standard, cleaning chores. Slobbiness versus clean freak. Choice of pet. Home decor. Personal space in the house. Freedom from each other. Give each other space. Bringing friends in. How invasive does it get? Body odor, how clean do you stay? Personal things, too much clutter is bad. Courteous manner. Leave stuff on the floor. Watch TV all night. Drinks too much. You cook all the time. He doesn't even wash the dishes. You want health food. He wants junk food. Bathroom cleanliness. Snooping into each other's personal things. Do you change surnames even if common law, especially if you have a kid? If you're looking for marriage material, watch out for people who come from divorced families because they already got that strike against them regarding long-term relationships. People who don't really believe in marriage, just jacking up. Your intuition says it'll never work out. You tally up a list of positives and negatives and they're either close or the positive side is not clearly dominant. Non-monogamous person who likes his fun on the side too. Feel like you're losing your identity, that this situation is smothering you somehow. You feel that he doesn't really love you, that he's just using you for casual sex and a meal ticket. You or he are angry, frustrated people always full of angst. Feel like you live on two different planets. Feel bored by him or her. The spark isn't there. Modern-day couples, brainwashed by the world, often make a big deal about the part of town to live in, the particular place itself, the decor of the place, etc. This is all crap. As long as the place is convenient to your daily business, everything else is noise provided it's a functional pad with electricity and water. Some people protect themselves legally by making up a cohabitation agreement discussed elsewhere or a kind of prenup except that they're not married. It's a basic contract detailing what she gets if she leaves. Books about unmarried couples are at #306.735 or HQ893.5 at the library. domparts.com. Nalo.com, Book Living Together, a legal guide for unmarried couples. Unmarried.org. Arguments against marriage. Marriage is a traditional institution. Some people say screw that. If I like someone we live together, then when we get tired of each other, we part ways, no legal entanglement mess. For some people, it's straight money. A marriage license and a wedding costs money that they do not want to spend. It's a symbol to not get legally married. You're stating that you live in the moment. If your mate gets bitchy, you can leave without getting tied up in the legal system. Many relationships quickly degenerate to a master-servant relationship and or domestic violence. With a marriage license, it's harder to leave than to just walk away. Most marriages are not equal. One has power over the other. Women and men are still frowned upon if they are single and childless past the age of 40. Is this good or bad? To thine own self be true. Don't listen to what society says you should do. Divorce is a tedious process that wastes time and will probably eat up half of your assets. The pro-marriage crowd. The counter-arguments are: marriage is blasted as the key to happiness every night on several TV shows. Every girl's dream is Mr. Right. Marriage is a part of virtually every religion. Marriage is moral responsibility. Children need a stable environment. Marriage has been in place for a long time, even if it was mostly a boss-servant relationship. People who criticize marriage are messed up people who do not know how to thrive in a relationship. People are so selfish and brainwashed that it's hard to find a good spouse. Marriage is not for everyone, but it is right for some people. A marriage license guarantees certain kinds of rights between each other, like hospital visitation, debts, power of attorney, inheritance, etc. Women and men are still frowned upon if they are single and childless past the age of 40. Is this good or bad? Common law cohabitation. In some states cohabitation is illegal, but in most, the government recognizes the common law marriage, which is essentially living together as a couple without the formality of a wedding ceremony and a marriage license if certain conditions are met, like length of time together, which must be significant, at least 2 years, file joint tax returns, the girl adopts the guy's last name, and they consider themselves husband and wife for all intents and purposes. You can check on common law laws in the common law states: Alabama, Colorado, D.C., Georgia, Idaho, Iowa, Kansas, Montana, New Hampshire, for estate settlement only, Ohio, Oklahoma, Pennsylvania, Rhode Island, South Carolina, Texas, Utah. Although an individual can use this as a legal basis in matters of separation, child custody, alimony, inheritance, etc., it is often a difficult process, and ultimately the best way to go for legal reasons is to tie the knot in a formal ceremony, or at least get the license and get it signed to make it legal. In many areas, if you're common law, together for 7 or more years, the court will recognize that as legal marriage for all intents and purposes. Common law marriages are on the increase these days for a number of reasons, one of which is to avoid the legal hassles of marriage. However, there is some basis for an equitable disbursement of assets after a breakup, because there's an implied agreement based on the couple's conduct. Hence, the woman is entitled to part of the man's earnings during the relationship if she lived together with him and did the housework duties and such. This Supreme Court finding is very tentative and subject to varying interpretations in different states and with different judges depending on where their sympathies lie. The most common problem is that of the disbursement of assets in case of split up, especially the ones where the couple went splits, like a house, car, dog, furniture, etc. The general procedure is each take what they went in with and try to split what they went splits on equitably. The girl has no rights to whatever assets the guy may have acquired during the cohabitation, even if he started a multi-million-dollar company and she helped him. The other big one is the death of one, in which case, the other is not automatically entitled to the estate. The immediate family is, namely parents and siblings. You need a will. If 2 people live together and split up, one can't sue for alimony but can sue for child support if applicable. Many wealthy older men and women choose common law over marriage to avoid money hassles if they were to get married and split up. It's that much simpler. If you want to get the common law spouse involved, you can do it selectively by making her the joint bank account holder or joint homeowner by putting her name on the deed. Conversely, you can keep whatever you want in your name. If you have medical and dental insurance at work, many companies have provisions allowing for domestic partners to be covered under the plan. Most states deal only with marriage and have no laws for dealing with common law relationships. Judges often decide on a case-by-case basis. Judges frown on sex for support arrangements like some girl living with you in exchange for sex. If it's not in exchange for friendship but in exchange for sex, there's no bond there, the judge will throw it out. Although the concept of living together without getting married is generally accepted within our society, several states have laws which could get you in trouble. For instance, fornication, which is sexual relations between unmarried people, is illegal in Georgia, Idaho, Mississippi, North Carolina, Rhode Island, South Carolina, Utah, and Virginia. Cohabitation, which is defined as two people of the opposite sex living together and having sexual relations without being married, is illegal in Florida, Idaho, Michigan, Mississippi, New Mexico, North Carolina, and Virginia. Even though you're in a supposed loving common law relationship, always protect yourself with documentation. If you're moving into an apartment, get your name on the lease too, so that he just can't kick you out if he wants to. If your name is not on the lease, he can kick you out legally anytime he wants to. Don't help pay for a car unless your name goes on the title with his. Don't get joint accounts because he might clean you out if he feels like it, and it's legal because his name is on the account. If you buy a house together, get your name on the deed. If you buy furniture together, make sure he pays his half, and even go as far as writing up a contract to declare ownership. If you're still married to someone while living with someone else, the court won't recognize the common law situation. In order to avoid a paper trail showing you supported your common law spouse, if you give her a check of $200 or more, write gift on the check so it doesn't show that you're supporting her, which will set a precedent in the case of a breakup. The 5 commandments of cohabitation arrangements are: be independent as though you were living single. Be honest with each other about money. Make up a cohabitation agreement. Each make up a will. Develop a balanced plan to pay the bills. In the end, talk to a lawyer or a paralegal about the law in your area. I've just covered the basics. Nalo Press has a book called The Living Together Kit, a legal guide for unmarried couples. You might find it at #346.7301 of your local library. In any case, check out your local library or courthouse for specific laws regarding the common law marriage. Cohabitation Agreement Info. An alternative to a full-fledged marriage license is the Cohabitation Agreement/domestic contract, a marriage contract without the marriage ceremony or license, where both sides put down on paper what they keep and what they own in the event of a breakup. Although they have some strength in a courtroom, they could be set aside if one party didn't enter it willingly nor understand what it meant, or one side used deception in disclosing all assets and liabilities. If you have children, both sides will have to be responsible to raise them. People in common law relationships should make up a written cohabitation agreement, which is one step towards marriage but less binding than a marriage contract, but it is a contract kind of like a friendly business contract. You should cover whatever you deem necessary, like allocation of assets upon termination of the relationship, car and real estate titles, assets acquired during the relationship, how to deal with children, child support, partner's medical costs, authorize partner to speak for you in case of medical crisis, in case of death, prepare a will, apartment lease, pet ownership, loan versus gifts, business ventures, investments, palimony, credit card bills. While you're at it, each of you should make up a will. In the end, consult a lawyer or paralegal about your cohabitation agreement. Ultimately, a judge decides on the value of these contracts in any legal proceedings. If you decide to get married, you can use it as the basis of a prenuptial agreement. If you don't have a cohabitation agreement, sometimes a verbal agreement might hold up in court, like if he told you that he'd take care of you for life during a romantic moment. 20 states have adopted the Uniform Premarital Agreement Act, which lets couples write up agreements regarding all manner of their relationship together, including divorce and death. Check it out at your local courthouse or a law library. They are Arizona, Arkansas, California, Hawaii, Illinois, Iowa, Kansas, Maine, Montana, Nebraska, Nevada, New Jersey, North Carolina, North Dakota, Oregon, Rhode Island, South Dakota, Texas, Utah, Virginia. Some states have laws for opposite-sex couples called significant other laws, which give some people in common law relationships some protections with or without a cohabitation agreement, but it's best to have one because it spells everything out on paper should a judge be forced to make a decision at some later date. Think of it as a prenuptial agreement without getting married. Marital property laws do not apply to couples who are not legally married, but courts everywhere are recognizing the validity of cohabitation relationships, and they are honoring cohabitation agreements, which are legal contracts. Therefore they must honor the legal definition of what a contract is. There are 4 tenets of a legal contract. It can be written. It can be oral. It can be implied. The court decides by examining the situation. If a judge cannot find evidence of an implied contract, he or she may presume that the parties intend to deal fairly with each other and find one party indebted to the other by invoking established legal doctrines of equity and fairness. People living together without getting married should make up a contract if they are together longer than a year, have kids together, one or both make a lot of money, you plan to share expenses, get joint ownership of everything, both names on all leases, and if one or both buy a house and other big items they both use. You can make up 2 types of agreements. One for money and property affairs. The other for how you will treat each other and live day by day. Make the business agreement for legal affairs and the personal agreement as a personal standard that you will live by. Make everything crystal clear. If it is the guy's house they move into, put it into the agreement that it's his house and that if you split up, he keeps it free and clear. If you agree to buy a house together, put it in the agreement that if you split up, you each own 50% equity in it. Make a list of what you each own separately. If you give the other a gift, write it up in the agreement that it is a gift. Write up a statement saying that in the event of a breakup, one person will not be legally bound to financially support the other. The more you keep assets separate and live as though you were single, the better off you will be if you split up. When you give your common law spouse anything, even money, always mark on the check or in the agreement that it's a gift. By doing this, you establish a trail that you are not financially responsible or supporting this other person. Gay people entering marriages in a place where gay marriages are not legal should make up a cohabitation agreement. Common law websites / unmarried couples websites. Divorcenet.com/states. en.wikipedia.org/wiki/common-law_marriage_in_the_united_states. ago.state.co.us/faq/clm_faq.cfm, Colorado. attorney-guide.com/common-law-marriage.htm. caudivorkianline.com/c-alpage/alimony/common law. cohabiting.org. colorado-family-law.com. divorce.co.uk/hot topics/articles/cohabitants.html, who will get the house if we split up? divorceinkentucky.com/unmarried_common-law.php. divorcenet.com/state/georgia/ga_common_law. divorcenet.com/state/oklahoma/common_law_m. en.wikipedia.org/wiki/cohabitation. en.wikipedia.org/wiki/common_law_marriage. equalityinmarriage.org/bmcommon.html. expertlaw.com/library/family_law/common_law. family.findlaw.com/marriage. familylawesquire.com. law.com/family/unmarried cohab/cohabitation. law.cornell.edu/topics/table_marriage.htm, state marriage statutes. lectlaw.com/def/c072.htm, legal definition of common law marriage. lectlaw.com/files/fam14.htm, unmarried couples living together. menstuff.org/issue/by-issue/commonlaw.html. ncsl.org/program/cif/commonlaw.htm. nalo.com/encyclopedia/article/mlt/sbhtml. palimony.com. unmarried.org. unmarried.org/common.html. unmarried.org/commonlaw.pdf. unmarried.org/common-law-marriage.html. Nalo Press. nalo.com. Book Living Together, A Legal Guide for Unmarried Couples. Chapter 4. Protect your money in case of divorce. Prenuptial Agreement. Marriage contracts could be a little bit different from prenuptial agreements because both sides will participate in putting it together, and it usually involves a personal way life is lived day by day, not necessarily the hardcore legal aspects. In Canada, a prenup is called a marriage contract. Basically, a premarital agreement is a contract between two people that defines the rights and benefits that will exist during the marriage and afterwards if there is a divorce. It usually limits the spouse's right to property and other benefits in the event of death or divorce. There is a federal Uniform Premarital Agreement Act, but every state has its own laws. If you are requesting the prenup, talk to your attorney to learn the specifics. Once you got it down on paper, tell your fiancée in a loving, honest, and tactful, sensitive-eyed way that you love her but you've been through hell before, and if she loves you, she'll understand that love is not about material things, therefore she should sign it to prove she's in love with you, not your money. Put the burden on her. Make her feel guilty, like she could be marrying you for impure reasons. If she refuses to sign, she has called your bluff. Either forget about her or swallow your pride and tear it up in front of her if she's worth it to you. Suggest that she have a similar agreement drawn up to protect her assets, then assure her that you love her and want to forget about the agreement. With a prenup, often one will draft one up and ask the other to sign, or each will make up their own. Beware of coercion in signing the prenup. If the guy making up a prenup makes it too unfair, the judge will reject it during divorce proceedings and give the other person a better share. The prenup is geared to stop the gold digger short. The longer the couple are married and the more children they have together, the more void the agreement is. One lawyer said not one of her clients who refused to sign was rejected by her suitor. They all got married. If you plan to have a prenup, don't wait until the wedding day. Give it to your bride at least a month before so she can look it over. Marriage contracts are often a trivial way to try to legislate a good marriage. Some marriage contracts call for 4 hugs a day, 1 hot-cooked meal a night, 2 babies in 4 years, etc., while a prenuptial agreement is different, based almost exclusively on 2 things. 1. What assets do I own that I want exempt from sharing in the event of a divorce, usually home, business, stocks, pension, etc. 2. What is it about the state/province's laws about distribution that I don't like, such that I will create my own plan now, get it in writing and signed in a legally binding contract? Other less urgent items in a prenuptial agreement are terms of support, based on length of the marriage, and child support. Child custody can't be decided in advance. Circumstances change, especially with the additone of kids, which is why prenuptial agreements are tentative at best. About 5% of first marriages and 20% of second marriages have the prenuptial agreement, also known as an anti-nuptial agreement. The prenuptial agreement is basically a contract made between the man and women before the marriage ceremony, usually about who owns what and the disbursement of assets in the event of breakup, that each agree to and sign in the presence of witnesses to make it legally binding. If one or both people own a large number of assets, such as with second marriages, a prenuptial agreement might be a good idea to avoid possible hassles later on. Prenuptial agreements take the spice out of romance, but they're necessary if one has significant assets and the other doesn't. If both have almost nothing but your personal property, don't waste your time. If each has acquired a home, car, some savings, etc., it might be worthwhile just to say that each will take away what you brought in and split the rest should you split up. The legal and financial obligations between spouses regardless of gender are obligations of mutual respect, fidelity, and support, meaning you have to help each other financially, and this is the way the law looks at spousal support in the divorce regardless of gender, which is why you sometimes see wives paying their husbands alimony. But beyond this, the only way to limit it if you're rich is to get an airtight proper prenuptial agreement that's been scrutinized on both sides by separate lawyers. PA are covered by the Federal Uniform Prenuptial Agreement Act/UPAA. State laws may differ slightly, but they're all based on the UPAA. The purpose of a PA is to bypass state laws regarding the disbursement of assets in case of a divorce, so use it that way and make it foolproof legally by following all the rules. In order to make the PA as valid as possible, have each side get their own lawyer to check it out, then both sign. If you don't do this, if there ever comes a day when the PA should be enforced, the judge can render it null, because if your wife didn't have a lawyer at the time of signing, the judge can easily think she's just an ordinary not-so-business-savvy girl who signed what her future husband wanted her to sign out of sheer naivete or coercion, him threatening not to go through with the marriage unless she signed. Full disclosure of all assets and liabilities is a must in order for the PA to be valid. The PA must be entered into freely without coercion, and the terms must be fair. In other words, the one with the money must make a fair offer to the spouse for her time to be fair as the wife, serving her husband in some way, even if it's as frivolous as being his escort for social functions. PA can easily be thrown out of court if they're not fair or agreed upon freely, so make sure each side has their own lawyer and be fair in the terms of a settlement should you two break up. Make it in ample time before the wedding, like at least 6 months, because the closer to the wedding it's signed, the more it will seem like coercion. Things that PA can't cover are child custody, illegal acts, sexual obligations, conditions to leave the spouse destitute or a ward of the state. Some tricky points that a PA could alleviate is a clause stating that when you die, your children inherit everything, not your spouse, as the law states in many states, that the spouse is automatically entitled to a portion of your estate regardless of what the will says. Anything you own before the marriage, specify this and the fact that it's yours exclusively by calling it separate property. The other sticky point is the spouse's responsibility for the partner's debts. Credit card companies and other loan agencies often put in fine print that the spouse is responsible for the person's debt should they be unable to pay, so put into the PA that you will not be legally responsible for your spouse's individual debts or a bankruptcy should he ever file for one. If you want to change the PA after marriage, follow the same procedure and have each side agree to it with their own lawyers. This is called a post-nuptial agreement. If you move from one state to another, check with your lawyer to see if you should draft up a new PA. In essence, a good PA now that will cost anywhere from a few $100s to a few thousand could save you a lot of money down the road in the event of a divorce. Generally, older established people, business owners, couples who each want it, couples where the wife will give up her career to stay home, unlikely couples like the old man and the young woman, whirlwind romances, couples where one has cheated before should all consider prenuptial agreements. Virtually all prenuptial agreements will cause some resentment in the one with the least amount of assets because she feels it's a violation of the implicit trust the new husband should have in his future wife. But I say, if you're worth something, screw the romance, save your ass, get that PA signed, or better still, don't get married, just live together. After it's signed, be aware of any hidden anger the one without the money has towards you for making her sign. If it gets too bad, either leave or tear up the agreement to show her you really love her. Better still, just tear up a photocopy of the agreement and keep the real one in case you ever need it. If she's really angry for making you sign, maybe she's not worth it in the first place. Even if you don't have a PA, you should do the steps behind them as a matter of course, like get what you both bring into the relationship on paper. Make a joint financial plan for the immediate future. Decide what each would leave with in the event of a divorce. Make up a will. Put a provision in that releases you from the burden of caring for the other in case of serious illness or accident, including nursing home bills, which would then put the responsibility on the state government. The bottom line is to try to make a fair deal which both sides are comfortable with. Write out how you would handle real estate, furniture, insurance beneficiary, debts, promises, credit cards, cars, financial aid to parents and children, religious practices, the assets each person brings into the marriage, the assets acquired during the marriage, dramatic increases in one person's wages during the marriage, compensation for the wife for becoming a housewife, sacrificing her career, retirement savings plans, health and dental insurance, bad credit and debts before marriage. Would you help her pay it off? Would you help your spouse with child support from other marriages? In case of divorce, how much support will be paid, for how long, and how will property be allocated? Distribution of both personal and business assets. Inheritance information. Insurance information. Personal property. Business property. Spousal support, alimony. Provisions for future alimony and child support. Adoption of children. Agreements as to duties in the marriage. Dispute resolution in the event of divorce. Virtually anything the couple agrees to. Prenuptial agreements generally keep things simple in the event of a divorce later on. That's their big advantage, but if the marriage lasts 5 or more years, you should get updated prenuptial agreements to keep them current, because a judge might not honor a prenuptial agreement more than 5 years old, since the dynamics have probably changed, like there are probably children in the equation now and different salaries. Prenuptial agreements are not romantic, but they do the job to protect your assets in this era of high divorce rates and save the hassle of a messy divorce later on. The best, simplest formula is each keep what they brought in and split what was acquired during the marriage 50-50. If you own a business, definitely get a prenuptial agreement to protect it in case the marriage fails. If a wife helps a guy through college while she works, you should get a prenuptial agreement getting some kind of protection that he will pay you back one way or another. You can put anything you want in a prenuptial agreement. What conditions will change the agreement? Length of time married. Addition of each new child. Tax, estate, or marital law changes. You can either write up a simple agreement yourself, get a prenuptial kit, nalo.com, get a marriage lawyer or a paralegal to draft one up for you. You can amend or nullify the PA anytime both of you want to. Prenuptial agreements can be contested, and generally, the longer the couple are married, the weaker the agreement. Prenuptial agreements are sometimes overturned, especially if there are children involved. The marriage lasts more than 5 years. Things changed dramatically during the marriage, like the husband started making a lot more money, and simply if the wife takes it to court and asks for more money than the ex-husband would like to give her. Wealthy women are now getting prenuptial agreements to protect their assets. If you intend to get a prenuptial agreement, the more formal it is, the more authentic it will seem to the court considering it at a later time, so either get a lawyer to do it or type up the agreement and get it signed by witnesses who are all corroborated by a notary public. If each side gets a lawyer and they both hammer it out, it will be a lot more authentic than if the husband pulls out an agreement with his lawyer and wants the wife to sign without her own lawyer checking it out. Prenuptial agreements are successfully contested when the conditions change after marriage. For example, if you get married with a prenuptial agreement and you're worth $100,000, but 10 years later when you divorce, you're worth $2 million, the court will tend to think that the assets gained during the marriage should be dispersed equitably. Many prenuptial agreements are not 100% upheld in court. The judge takes all factors into consideration when making his decisions. Some people use a sunset clause in their prenuptial agreement which renders it null and void in the event of some condition like the birth of a son or after 5 years of marriage or something like that. Prenuptial agreements may give off the impression that they kill romance, but they are necessary in a community property state when one spouse is quite wealthy and the other not so. Before you sign the prenuptial agreement, have each party take an inventory of their assets and liabilities and include it with the agreement. Familiarize yourself with your particular state laws regarding divorce. Think twice before you put anything into joint ownership like the house. Update your wills frequently. Consolidate or coordinate medical insurance and change beneficiaries in your insurance policies. If you were married before, make up a will or a trust to leave some money to children from the earlier marriage in case something happens. Without this agreement, you're giving state law and ultimately a judge the power to determine the allocation of your assets in the event of divorce, so if you have lots of money, consider getting it done. In the final analysis, don't get too nitpicky in a prenuptial agreement, otherwise you might alienate your spouse. Do it in plenty of time before the wedding date to give it time to wear off. Post-Nuptial Agreement. There are such things as post-nuptial agreements done in community property states where one party, usually the husband, makes a lot of money during the marriage and makes up a contract that he wants his wife to sign like a prenuptial agreement after marriage. There's no romance there, but some people, especially those who have gone through a divorce, are doing this. There are other reasons for it beyond just protecting money. One guy wanted to curb his wife's spending habits, so he made up a post-nuptial agreement to limit her to a budget. They are not supposed to be made up in anticipation of a divorce, but to help smooth over a rough spot so both sides are clear. They seem to be the first step in many divorces. OneStopLegal.com, download post-nuptial agreement. Divorce-lawyer-source.com/news/postnuptial-agreement. Divorcenet.com/states. equalityinmarriage.org/dmpost.html. law.freeadvice.com. legalmatch.com/law-library/article/postnuptial. pro-legal-forms.com. thelawencyclopedia.com. Palimony, common law divorce obligation. Palimony is one side, usually the husband, either agreeing to pay alimony to his ex-common law wife or being forced by the court to do so. In order to win, the girl has to prove that he promised to support her. Palimony is alimony for an unmarried couple after a split. If two people live together then split and one decides to sue the other for financial support, it's often for either or both of two reasons. She was with him for a long time, supported him in his career development, now deserves something. He made a promise to her, usually verbal, that he would take care of her for life no matter what. The two sides go to civil court and hash it out. The judge or judge and jury makes a decision and that's it. The one seeking support must file the suit through civil court. Palimony laws vary state by state. Protect yourself by living independently while you live with him, such that if he leaves, it's not like you're overly dependent on him. In order to counteract a misunderstanding, make up a cohabitation agreement. Nalo.com, book Living Together, a legal guide for unmarried couples. Palimony.com. Chapter 5. Change your name legally. Changing your name because of marriage. For the bride, you have the choice to keep your maiden name, change to your husband's name, or hyphenate and keep both. Sometimes the man changes to the girl's last name, or each takes a part of their last names and combines them to make a completely new name. If you use your maiden name at work and your husband's name socially, you may run into problems with taxes, etc. If you change it to a new hybrid name, consider a mass mailing to get the word out. With divorces and marriages, you can change your name on the marriage or divorce license, then use that document to change your passport, social security, driver's license, etc. without bothering with the court petition method. Once you have decided to adopt and use a new name, you have to inform your employer, friends, family members, creditors, etc. Inform them that you now want them to call you and use only your new name. If applying for a new job or securing for credit, you have to use your new name. You may not use your old name and new name simultaneously. Changing your name. Some people overwhelmed by money problems, a bad reputation, a criminal past, etc. decide to change their names legally to get a fresh start. Common law asserts that you can change your name on a whim and start using it in day-to-day affairs as long there's no intent to defraud anyone. If you want to change your name legally on your identification cards, you have to do it via court order or decree. Government agencies generally grant women name changes on public records after marriage without having to get a court order. You may not adopt the name of a famous personality or the brand name of a popular product. Wanting to change your name for that purpose can be considered as one with malicious intent. Every state has at least one method to change an individual's name, but some states have two methods. These are commonly known as court petition, adopted use method. Depending on the state in which you live, both are legal and valid methods. For example, California residents have the right to be known by whatever first and last name they choose. Changing your name, court petition. The most popular way an individual can legally change his or her name is through what is called court petition method. A name change by this method is accomplished by simply completing name change form and by filing it with the county clerk's office. At court, the judge will ask you a few questions to try to make sure that you are not changing your name for the purpose of deceit or fraud. If he or she approves of your new name, this name change will be valid in all 50 states and the District of Columbia. This method is quite similar to the process involved when you register the name of a business, called DBA, doing business as. You fill out the proper forms, file it with the county clerk and then publish a notice of filing in a local newspaper. The objective of this notice is to publicly announce your intention to change your name. This notice also allows any person who may have any good reason to object, to file a motion against your name change. However, if your notice is properly published and has served its term, usually 4 weeks or 30 days, the court will grant your request for name change. Generally, what you need is a petition to change a name form either from the clerk who handles name changes at the county court office or from a stationery store. Every state has a particular statute for the procedure. You have to fill the form in with your name, date, and place of birth, current address, reason for the name change and proposed new name. In some states, you must specify whether you have ever been convicted of any criminal charges, whether you have any liens or debts against you, and whether you have ever declared bankruptcy. In some cases, you might have to get the form notarized and add a verification form, which is a statement saying that you swear that you have no fraudulent intent with the new name. You must then publish the intention of name change. Usually this is done by placing an ad in the local newspaper. This act gives the public the chance to see this and possibly contest it like a creditor or another person with the same name. After a few weeks pass and no one contests your intent of name change, the judge issues a court order stating that the name requested is now your legal name. With this document, you can get the name on your social security card, birth certificate, and driver's license changed. Other documents which could change names are adoptions and divorces. The best reasons to give for changing your name are to make it simpler for others to use, to hide out if you are escaping from an abusive relationship, or if you're an entertainer and want to take on your stage name. With divorces and marriages, you can change your name on the marriage or divorce license, then use that document to change your passport, social security, driver's license, etc. without bothering with the court petition method. Once you have decided to adopt and use a new name, you have to inform your employer, friends, family members, creditors, etc. Inform them that you now want them to call you and use only your new name. If applying for a new job or securing for credit, you have to use your new name. You may not use your old name and new name simultaneously. Start by changing your driver's license and your social security card. Send a copy of your court order to the Vital Statistics Office in the state you were born to change your birth certificate. After this, change all your other documents and paperwork like academic institutions, bank, car registration, contracts, credit card agencies, insurance, Internal Revenue Service, passport, powers of attorney, professional associations, real estate, retirement plans, Stocks/bonds/mutual funds. The post office. Trusts. Utility companies. Veterans Administration. Your doctor. Your employer. Your lawyer. Your will, also if you're in another person's will. Send them all a letter with your new name and a copy of your court order asking them to change your name on their records. You can bypass a lot of the paperwork by hiring a lawyer or a paralegal to do it for you. Immigrants are allowed to change their name when they become citizens. Simply tell the immigration officer you want to change your name because you want a simpler, more common name. A minor can change his or her name. An adult will have to give their consent and submit the petition with a reason for the name change. The reason is often adoption or bringing a stepchild into a family. Both parents or guardians will be notified of the petition so that if one parent objects, they can argue against it and leave the judge to decide what is in the best interest for the child. angelfire.com/moss/dnsassociation/tools.html, the free bridal legal name change toolkit. kitbiz.com. namechangelaw.com. namechangers.com. uslegalforms.com. Wedding Name Change Kit. 753G Santa Ana Canyon RD. Anaheim, California, 92807. 714-281-5013. Changing your name, adopted use method. As its name suggests, changing your name using the adopted use method means simply that you adopt a new name and use that name in all aspects of your personal, social and business life. Unfortunately, this method is not acceptable in some states. Therefore, if the state in which you presently reside does not recognize the adopted use method, simply set up a residence in a state that has the usage provision and change your name there. With the use method, you don't need a lawyer or a trip to the courthouse, but the drawback is that the name is not legally registered anywhere. You begin using your new name in daily use, but you will not be able to use your name for official, legal things that require documentation like opening a bank account and getting a driver's license, buying a plane ticket, getting stopped by the cops, etc. This method is valid and legal except in situations where you need formal ID. If you want to change your name for privacy reasons, pick a common name, one that is shared with thousands of others. Look at the street names in your area. They often make great last names. The most common male first names are John, William, Bill, James, Charles, Peter, Robert, Paul, and George. The most common female first names are Jane, Mary, Nancy, Betty, Susan, Debbie, and Barbara. drbecky.com/birthcert.html. Change your name websites. namechangelaw.com. changeyourlastname.com. changeyourname.co.uk. change-your-name.com, United Kingdom. courtinfo.ca.gov/self-help/other/name-change-form.htm. en.wikipedia.org/wiki/deed_of_change_of_name. en.wikipedia.org/wiki/name_change. floridanamechange.com. illinoisnamechange.com. lawguru.com/legalforms/name_change_c505.html. legalhelper.net/change-name.aspx. legalmessenger.com/legal-name-change.htm. legalzoom.com. namechange123.com. namechangelaw.com. nalo.com. soyou1.site/site/syws/changename/changename.html. ssa.gov/replace_sscard.html, apply for a new or replacement SSN card. texasnamechange.com. texasnamechangelaw.com. uslegalforms.com/change of name.